Thank you for your time. So I represent Karma Global. Karma Global, I'll give you a small brief about what Karma Global is, and I'm thankful for opportunity to believe in us, and we've been believing in each other since ages now. So Karma Global, we are a compliance, tech staffing, and a tech automation company. We have our operations in India, US, UK, and Canada. We are the pioneers of compliance and tech compliance both in our country. Further, there are any requirements or any queries, you may reach out to Jagrati or you may reach out to Asmita. We'll be sharing in the contact and communication details. If you have any queries for that as well, we'll be sharing in those links. You can come up anytime. I'm passing on the baton to Asmita now. She'll be taking up the POSH training. All the best, people. Make best of it. Thank you.
Thank you so much, sir.
Thank you. Thank you, Coach. So, welcome everyone. I extend a warm welcome to everyone who has joined this session. And thank you for joining this session on POSH Awareness. And first of all, I would like to tell you the advisory services which we provide through Karma Global. So in Karma Global, we provide advisory services like we provide you with the all types of notifications of minimum wages, and we provide you the salient features of the employment laws, means what is the exact act says, what is the understanding of the laws. We provide you with easy access to day-to-day queries with respect to labor laws specifically. Karma Global focuses only on labor laws. So whatever queries you have with respect to all types of laws which are connected with labors, we handle those cases, we handle those queries. Next, we also provide you with the compliance update. Whatever with due dates of the remittances under various acts or filing of returns, what are the exactly due dates and compliance related aspects are covered by the advisory services. We provide you with the updates on notifications or amendments whenever there are changes happening in any type of labor laws. Then we provide you with the training material, like we train the internal teams also on acts and compliances, which is required under the acts. Then we provide you drafting services. We provide you services which helps you while dealing with the local authorities or government authorities in cases of labor laws. Then we provide you monthly case law digest, which is important for labor law judgments. Then we provide you advisory on new branch opening if you want to open any type of establishments. Then we provide you what are the compliances required for the new establishment or a new branch opening. We also represent on behalf of our clients in front of the labor authorities or the labor department. And we provide advisory for onboarding and exit of vendors also. Then we also provide the dispute matters, means in cases of trade union and employee grievances which arise between the trade unions and the companies. We provide you the legal advice as to how you can resolve these disputes. Then we approach the employee grievances such as absconding, misconduct, or such type of cases. We provide legal advices on that. We are also creating internal policies such as ethics policy, misconduct policy, sexual harassment policy. We provide you advisory and help on implementation of labor codes as and when they are applicable. And this is a separate activity from advisory services, and this will be the chargeable thing. Then we also provide the legal opinion and representation in court for compliances related issues. So if you are if you want any type of legal opinion and you want us to represent in court for compliance matters, we also provide you services. So you means I've first giving you a brief of the acts covered under these advisory services are like Apprentice Act, Minimum Wages Act, Building and Other Construction Workers Act, which is known as BOCW. Then Employees Compensation Act, Payment of Wages Act, Contract Labor Regulation Abolition Act. Then we have Employee State Insurance,
33 participants.
EPFO. Then we have Equal Remuneration Act, Maternity Benefit Act, We
अच्छा,
also
हाँ,
have
अच्छा,
Industrial
चैट
Employment,
ठीक है।
Industrial
अच्छा,
Disputes
आप कर
Act.
रहे थे, मैं नहीं join हुआ।
मेरा तो
Uh,
लास्ट में था डिस्कशन टाइप।
ओके ओके,
मैंने जल्दी से रैप अप कर दिया क्योंकि उसमें बोला था 5 बजे तक है।
Yes, thank you. So these type of acts are covered under this.
Ma'am, your
Tell
voice
you
is
that
not
in
audible
case
to
you
me. Hello?
yes,
Yeah, ma'am, your voice is not audible actually. It's
just
breaking sometime.
just
Also, please share the screen. We
yes,
cannot see the screen.
yes. I'm going to share my screen as
I would suggest that
well.
you can keep your video off and you can share the screen and go ahead because
So meanwhile, Asmita reconnects people. I am sharing in a link in the chat box. You can download the application, which is at no cost. That is in sync with the synergy that we have with Opportune Technologies. This app will help you with all the updates for labor compliances and all the notification that come up. It is shareable. You can share it to your peer groups as well. The link is shared in the chat box. By the time Asmita comes back, I'm here. Give us a minute. I'll just connect with Asmita and check the connectivity soon. Give me a minute.
Hello. Yes, am I audible?
Yes, Asmita, you're audible.
So sorry for the inconvenience. There was a glitch in network. Let me share my screen and we'll start with the presentation.
Okay.
Yes, is my screen visible? Yes, thank you. So as I mentioned, the scope of advisory services which we provide under Karma Global. Now let's start with the training. So as you know, there are lots of myths and very little clarity surrounding the definition of sexual harassment. So many people, many women don't know exactly what is sexual harassment. They are victim of it, but they are unaware of their rights and responsibilities in case they are suffering from sexual harassment. So we have also heard about lots of social movements like Me Too movement, which has happened in India and overall the world. And there are lots of cases of sexual harassment at workplace in pan India as well as globally. And many of us have been a victim of sexual harassment at the workplace, but they are unaware how to deal with it and whom to address. So this is why the POSH training becomes mandatory, as this training would help them to understand what they can do in case they are a victim of sexual harassment. So at the end of this session, you will be able to understand what is exactly sexual harassment, what are the global initiatives taken for prevention of sexual harassment. You will be able to understand, or you will know what was the exact background behind enacting the POSH Act. and what are the prevention, prohibition, and redressal mechanism in POSH. You will also be able to understand how to work towards the safe and secure workplaces. So, what is POSH training? So, first of all, Government of India has enacted the Sexual Harassment of a Woman at Workplace Prevention, Prohibition, and Redressal Act 2013. So, POSH definition is prevention of sexual harassment of women at workplace. So, this is the full form of POSH Act. And this act holds an all the organizations or the employers responsible for taking the preventive measures to prevent the incidents of sexual harassment at workplace. The act also lays down the several measures for organizations to be compliant to the act, and one of them is spreading the POSH awareness to all the employees through conducting these types of training, or putting up a POSH policy in their offices. In the main center place of the office, they have to put out a notice or a policy abstract wherein the employees have access and they could read that policy and they could understand their rights and responsibilities in case of sexual harassment. And under this POSH Act is made mandatory for every organization who has 10 or more women employees. The organization has a responsibility. If they have 10 or more women employees, they have to appoint a POSH committee. Okay, this is the first mandatory thing which is made under POSH Act. And if the second thing is the employer has to conduct a training with respect to POSH awareness. And if that employer or the organization has not conducted any type of such training, then they are attracted to a heavy penalty of rupees 50,000 for the first time, and the authorities might cancel the business license for repeated offenses if the employer is not following the laws. And many times what happens is your colleagues or your friends might have been victim of sexual harassment, but you want to help them, but you are unaware like how you can help them. So in this case also POSH training will help you. So this is why the POSH training comes in picture, and every employer has to comply with this POSH training in their organization. So the POSH Act is based on, or was formulated or based on the two things, which was the Constitution of India, and the second one is the Vishakha Guidelines of 1997. I hope everyone is able to understand what I'm saying, or if I'm going too fast, just ping me, or you can drop a message on chat box. Okay.
Sure, Asmita.
Yes, thank you. So POSH was formulated, as I said, POSH was formulated based on two things, which was the Constitution of India, and the second one is the Vishakha Guidelines of 1997. So under the Constitution of India, you can see Article 14, 15, and 21. These articles are provided as a fundamental rights, and everyone under these articles, everyone is guaranteed equal treatment under the law. They have a right to be free from discrimination on any ground, and they have a right to live a free and independent life. And workplace sexual harassment is also considered under Article 21. And workplace sexual harassment is a serious form of sex discrimination in the workplace that causes serious harm. So Article 21 gives the right to live with human dignity, free from exploitation. Second is the Article 91G, which also helps which covers the sexual harassment at workplace policy, like any and all forms of sexual harassment at workplace affects their ability to carry out the duties as per the terms of their employment by creating a hostile or offensive workplace. In turn, the fundamental right of a person to carry on his profession or carry out his or her trade or profession is affected. That's why Article 19 covers the sexual harassment at workplace, because it affects the entire workplace and it affects the entire life or the profession or the career of that person. Then next one is the Vishaka guidelines. So with respect to Vishaka guidelines, I'll take you back to the 1992 case and tell you what are the Vishaka guidelines, what led the POSH as an act to be promulgated by the legal system in India, because POSH is specifically created for India. And before POSH came into picture, Vishaka guidelines were followed in cases of sexual harassment at workplace. So Vishaka guidelines was considered as a law until the POSH Act was enacted. So I'll tell you quickly what was exactly the case of Vishaka versus the state of Rajasthan. So in 1992, there was a Dalit woman in Rajasthan her name was Bhavri Devi, and she was working for government of India. And she was working for the role was to work for women development, women upliftment. She was working for the rights of women. She was creating awareness about child marriage, female infanticide, dowry, etc. While she was doing this work, what happened is in Rajasthan, in that in her village, there was one family which was they were considered as a high caste family, and they were marrying their 9 months old daughter. So what Bhavri Devi did, she tried to stop that family from marrying their daughter, and she filed a complaint with the police station, but the police authorities did not consider her complaint, and she still was trying to stop that marriage. And what happened was the people of that family, they felt like they were insulted, and how can a low caste person come to us and stop us from doing what we want to. So they were very much aggrieved by this act of this Bhavri Devi. So what they did is they decided that to stop her by giving her punishment, and the punishment was gang rape. So the group of people of that family raped her.
24 hours
Now this became a huge huge hue and cry, and several NGOs took this call of Bhavri Devi, and Vishaka was one of the NGOs. Means lots of NGOs came forward to talk on this and to raise this case, but Vishaka was one of the NGO who took this matter to the Supreme Court. And what happened at that time was the state washed their hands off, stating that the rape was not the rape was done in the field of Rajasthan and not in the office. Means the Bhavri Devi was at that time was not in the office, she was not at her workplace. That's why they said that this case would not be considered, as she was not on her duty. So that is why NGOs took this matter to Supreme Court, and Supreme Court acknowledged a few guidelines which will help the women to protect themselves at the workplace. And these guidelines were means they have provided the guidelines, they gave few statements which will help to clarify what kind of sexual harassment is, and what will be the steps to follow in case of sexual harassment at workplace. So they have defined certain sexual harassment. They have said that sexual harassment is considered as a violation of human rights. The Supreme Court said that sexual harassment is considered as a violation of human rights. It's a violation of constitutionally guaranteed fundamental rights under Article 14, 15, and 21. And they say the Supreme Court said that there is a need to frame guidelines to fill the legislative vacuum. It has specifically defined the sexual harassment. Means what is exactly sexual harassment is defined under this under these guidelines, which is any uninvited physical touch, any unwanted conduct, request of sexual favors. Okay. Such type of acts will be considered as sexual harassment. Then the main judgment, what was the judgment passed in this case was the main ingredients of these guidelines issued by the Honorable Supreme Court of India were the definition of sexual harassment, provide a safer working environment, means it is the duty of the employer to provide a safe working environment for each and every employee. Then the third was duty of the employer to file a complaint. Means the guideline also lays down the obligation of employer to file a complaint if conduct towards an employee amounts to criminal offense, which is punishable under IPC. So employer needs to initiate an action and ensure that witnesses are not further victimized. Then the complaint redressal committee. The guidelines made it compulsory for all the organizations to set up a complaint redressal committee to ensure the complaints are dealt with and suitable action is taken. Then employer to assist the employee if she is sexually harassed. If an employee is harassed or tortured by third party, just like in case of Bhavri Devi, then employer should assist the employee in every possible manner, like which didn't happen in case of Bhavri Devi. So the employer denied all the responsibilities, and the guidelines provide that the employer are required to assist the employee in terms of both preventive actions and support the victim. Then the duty of employer to spread awareness. So it will be a duty of employer to spread awareness in organization with respect to sexual harassment and safety of women, which can be done by conducting training or conducting workshops. Lastly, the duty of government to widen the scope of these guidelines. So government also has to strive and has to pass the necessary legislations to widen the scope of these guidelines. And when POSH Act came, it was the POSH was replaced by the Vishaka guidelines were replaced by the POSH Act. Till then, Vishaka guidelines were followed as a law. So next, what are the global initiatives in prevention of sexual harassment? So the International Labour Organization, which is ILO, it has also aimed on preventing and creating a safer workplace, prevention of sexual harassment and creation of a safer workplace for all types of employees, not only women, but also for men. So the organization views sexual harassment at the workplace as any unwarranted sexual conduct that creates a hostile or offensive work environment. So ILO has also specifically given a definition of sexual harassment, which is unwarranted sexual conduct that creates a hostile or offensive work environment. Then CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women. So CEDAW, it was implemented in 1979 by United Nations General Assembly, and the convention describes discrimination against women as any exclusion or a restriction made based on sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. So this type of discrimination against women would not be tolerated, and it would be penalized. So the main thing, what is sexual harassment at workplace? So many of us might know what is sexual harassment at workplace. So the POSH Act 2013 has provided a broad and inclusive definition of sexual harassment, which includes unwelcome sexual behavior, whether directly or by implication. Then the POSH Act provides that what would be considered as a sexual harassment. First is the physical contact and advances, demanding or requesting of sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical or verbal conduct of a sexual nature. So whether any particular act or behavior would amount to sexual harassment, it will depend on the facts and circumstances of the situation. So further, the act is also commenting on the complainant's dress and outfits, suggesting that one would make work difficult for the employee if she was not good to him, speaking in a manner which was offensive to her dignity and chastity. So these all types of conducts comes under the sexual harassment of workplace. So I'll tell you one example of how a person creates a hostile environment. Like one person, say Michael. So he is a supervisor of 12 people. Okay, and he is interested in a teammate, in his teammate Rosie. So she works under him, and she is a junior to him. So he tries to ask her out frequently for a coffee, for a date, but Rosie turns him down every time. So what Michael did is he stopped talking to her. He stopped all the personal communication with her, and he communicated with her through other people. He didn't directly interacted with her. He used to call someone else, and he used to give some work to her through other people. He purposely, what he did, he used to arrange meeting when she was not at her workplace, or when she was out. Then he didn't inform about the changes or meeting whenever it happened. So it resulted in errors. Like she used to create lots of mistakes, and she was not able to update herself according to the work. So it affected her work, and she received written reprimand. She was not given leave. So these type of environment was purposely created. This type of environment is called the hostile work environment. So because of this, she became frustrated, and she filed a case of sexual harassment. So you can understand like what type of conduct can come under sexual harassment. So under the POSH Act, there were three definitions, which the first one we saw of sexual harassment. The second is employee. So how employee is defined under the POSH Act is, means who will be the employee considered as it will be considered for every employee. Means be it a regular employee, be it a temporary or an ad hoc employee, an employee who is engaged on contractual basis, on a daily wage position, or directly or through an agent, a co-worker or a probationer or a trainee and a apprentice, whether he is remunerated or not. So every type of employee means all the individuals who are working for that company will be considered as employee. Even the housekeeping staff will be considered as employee. So the next definition was workplace. This was very much important because like in Bhavi Devi case, the state of Rajasthan, the authorities washed their hands and they said no, this crime was not taken place at workplace. So the definition of workplace was specifically designed considering these types of situations. So it is said that workplace is not confined to any physical space or office of the employer. It also extends beyond the office premises, where that employee is visiting or during the course of employment, that person has to visit, which will include transportation also. Like if you're traveling from your office to some client's place, or from your home to a client's place, which you are required to go for the work purpose. So that journey will also be considered as workplace. Clear, everyone? Next is, I hope everyone is clear. If you guys have any type of doubt, check. Yes, we'll go through the question and answers at the end of the session. Okay, so how to recognize the sexual harassment? So like I said in the previous definition also, how to what is the sexual harassment? So how you will identify that this is a sexual harassment? So workplace sexual harassment is any type of behavior that is unwelcome, which is sexual in nature. Okay, unwelcome means you didn't ask for it. Sexual in nature is which includes a physical touch, a verbally abuse, or saying some kind of words which will not please the other person, purposely doing these things. And subjective experience. Subjective experience means person to persons the experience might differ. Like what I feel okay, that the same thing will not be okay, or not be considered as good by other person. Like if you are sitting at your workplace and some of your colleague comes and he puts your hand on your arms, just regular, without intention, or with intention, doesn't matter. So if I am comfortable with that person, I won't feel anything. But even if I am comfortable with that person, he's close to me, but still I might feel sometimes that the distance should be maintained, and this is not what I like. And the same thing might be liked by the other person. So this is subjective experience. So every time it may not come under sexual harassment. Next is the impact matters and not intent, which means the same, like what is the intention of that person behind doing that, it is not considered. What the result is, what the impact is on that other person, only that is considered. And occurs within the matrix of power means like the sometimes it happens like that person is superior to you, and that's why you won't be able to say anything, even if you are victim of that sexual harassment. So in this situation also, it will come under sexual behavior, like sexual harassment, and this type of conduct will be considered as sexual harassment itself. So these are some types of instances which indicates the underlying workplace sexual harassment, and which will attract the inquiry. Okay, so criticizing, insulting, blaming, reprimanding, or condemning an employee in public, purposely doing that means if an superior purposely blames you for the mistakes you have done in, and he calls you in front of everyone and he blames you in front of everyone, this type of means the purposely done thing is also considered as sexual behavior, sexual harassment. Then exclusion from group activities or assignments without a valid reason, right? Like giving you assignments which you are not supposed to do, or giving those assignments after the working hours, means the shift is about to get over and that person gives you assignments. Okay, he purposely excludes you from group activities. Statements damaging a person's reputation or career means gossiping about another person, saying some wrong and bad things, false things about a person which may damage the reputation or career of that person. Purposely removing the areas of responsibility, or unjustifiably not giving them some kind of work, or giving them too little or too much of work. Constantly overruling authority without just cause, blaming an individual constantly for errors without just cause, repeatedly singling out an employee by assigning her with demeaning and belittling jobs, like there is a person who is your teammate, and you ask him to do the work which she is not supposed to do. Like if you ask her to bring coffee, yeah, she brings it for you, but you ask her to wash that cup and keep, and you do it frequently. So this is a demeaning and a belittling of jobs, which is considered as sexual harassment. So constant insults or humiliations, repeated attempts to exclude or isolate a person, systematically interfering with normal work conditions, sabotaging places or instruments of work, then humiliating a person in front of colleagues, engaging in smear campaigns, arbitrarily taking disciplinary actions against an employee, means using their power or using their authority, they are taking disciplinary action against an employee. Then controlling the person by withholding resources, time, budget, autonomy, and training necessary to succeed, means you will purposely not provide the proper training to that person. If that person asks you for some kind of approval, you won't give that approval. So this type of behavior also comes under harassment. So there are certain instances also which will not be considered as sexual harassment. So following up on work absences, requiring performance to job standards, means if your senior is continuously following up for the work, following up on the work which is assigned to you, or if you are absent on work, you are taking frequent leaves, so that person has authority to ask you, so that will not considered as sexual harassment. Then requiring performance to job standards, means whatever the role and responsibilities has been given to you, and if you're not performing those responsibilities, not performing that role, then that person might ask you for the reasons, or she might give you a warning letter to perform the job. So that would not considered as sexual harassment. The normal exercise of management drives, work-related stress, example, the meeting deadlines or quality standards, this again will not considered as sexual harassment, because meeting the deadlines or quality standards is your lookout, like the employee has to perform it, and it's their responsibility, it's their role to complete the work in given deadlines. Then conditions of work, constructive feedback about the work mistake and not the person, like if that person if you have been given feedback for the work or feedback for the mistakes you have done, that time also it will not be considered as sexual harassment. Then there are two types of workplace sexual harassment. It's forms of workplace sexual harassment. So these are considered as inappropriate behavior. The first one is quid pro quo. So literally, it means this for that. Like if you ask some kind of favor from something, and you will give something in return. Okay, like implied or explicit promise of preferential or detrimental treatment in employment, or implied or expressed threat about her present or future employment status. So if like I'm asking for some kind of sexual favor from a person, and I am promising that person that yes, if you give me this, I will promote you, I will give you extra leaves, I will give you an increment, and this type of behavior will be considered as inappropriate behavior. Plus that person is threatened about their present or future employment status, that if you are not accepting my request, or if you are not coming out with me, if you are not accepting my proposal, I will terminate you, I will damage your reputation. So this type of threat is given to that employee, and due to that threat, the victim is accepting that proposal, they are giving that type of service to that culprit. Okay, so this is quid pro quo. Then the hostile work environment, this is another type of inappropriate behavior, means the creating a hostile or intimidating or an offensive work environment, humiliating treatment likely to affect her health or safety. Okay, so this again, like I explained in the previous example, creating a hostile environment or an offensive work environment is also considered as inappropriate behavior. So what is POSH and what are the three things which are considered under POSH? So through compliance with the above mentioned three elements, which are prohibition, prevention, and redressal, the Act seeks to ensure women's equal access to the workplace, free from sexual harassment, as stipulated in the Vishaka judgment, and the Act provides women with a civil remedy in addition to other laws currently in effect. Like if you, the woman, specifically woman has an remedy under POSH to file a complaint under POSH, but if in case a woman is not able to file a POSH complaint, she has other civil remedy which she can file a case under IPC also. So we'll be going through those slides in coming slides only. So the first important provision of POSH Act was Internal Complaints Committee, formation of the Internal Complaints Committee. So under Section 4 of the POSH Act, every office or branch of an organization employing 10 or more women employees must have an internal committee dedicated to hearing and resolving sexual harassment complaints. So this is a mandatory thing, and every organization has to form an internal complaints committee for this purpose. Next is composition. So who will be the members of this committee? The one will be the female presiding officer, who is an employee at a senior level or an employer at a senior level. Then 2 members among the employees which are committed to women's causes or having social work experience and legal knowledge. And 1 will be an external member which can be taken from an NGO who has an experience in the issues faced by dealing with the issues faced by women in workplace. So half of the committee members should be female, and they shall serve for a maximum of 3 years. So this internal complaints committee shall be valid for 3 years, maximum of 3 years. So after 3 years, they have to decompose the committee. Then local committee. So in case if you are if there is no internal complaints committee, if the company does not have women employees more than 10, what kind of committee they will establish? They will establish local committee under Section 5 of the POSH Act. So the district governments are required to set up a local committees to investigate and respond to the complaints of sexual harassment from unorganized sector, which means the companies which have less than 10 employees. Okay. So local committee can be formed, and these local committee will look out the instances of sexual harassment of domestic workers, or when the complaint involves the employer or a third party not employed by the company. So the composition of this local committee will also be same as the internal complaints committee. Then what are the powers of the committee? So the powers of this committee includes the right to investigate, right to inquire, then summoning and requiring the attendance of any persons and interrogating him under oath, a requirement to discover and produce documents, and such other matters. Like if a person is required to come in person and give the witness, the committee can ask that person to do that. And this the same powers, the powers are given to the local committee under CPC, that is Code of Civil Procedure 1908. And what is the procedure of complaint? So whenever there is a case of sexual harassment, the woman aggrieved, she may file a complaint of sexual harassment at workplace, and this complaint should be filed within 3 months. So the period for filing a complaint is only 3 months from the date of the incident. And if the incident is a repeated incident, within 3 months of the most recent incident. So if the incident is frequently happening with that woman, aggrieved woman, then what is the latest date of that incident will be considered for calculating the 3 months period. Okay, once she files the complaint, sexual harassment complaint, that complaint is to be addressed within 7 days by the committee. If that aggrieved woman is not able to file a sexual harassment complaint within 3 months, she may get a time limit, extended time limit. If stipulated, if a valid and a justified reason is provided, then the committee may extend that time, and that time will not be extended more than 3 months. Means another 3 months can be given and not more than that. Okay. Then if the woman cannot make a complaint in writing, or she is not able to come up and give her complaint, if she is like physically or mentally incapable, or she is traumatized so much and she is afraid of filing a complaint, then on her behalf, presiding officer or any member of the internal complaints committee or the chairperson or any member of the local committee will provide her with all the reasonable assistance to file a complaint in writing. And for such type of aggrieved woman, in case she dies or she is mentally incapable, her relatives or her legal heir or her friend, her co-worker, or an officer of the National Commission for Women or State Women's Commission, or any person who has knowledge of that incident, that person may file a written complaint with under the POSH Act. Okay, clear with the procedure of complaint? Yes. Now, what should be included in the complaint? So, first of all, the respondent's name. Many times it may happen like you are not aware of the name of that person, but that person has conducted a sexual harassment and you want to file a complaint. So the name, in some cases, if it's not available, then it might help the inquiry committee or the local committee will decide on how to find out the name. But she can at least identify that person, and then the name can be called out. So respondent's name is compulsory. The date of incident is compulsory. The time of the incident, and the working relationship between the parties, like who is that person in your workplace? Is your senior, is your junior, or a similar level person, whoever it is. So that type of working relationship between the parties should also be mentioned in the complaint. So another redressal or another remedy you can consider is under Section 10 of the POSH Act. If an internal committee or the local committee attempts to resolve a complaint between the parties, okay, like if the aggrieved woman wants that, no, I don't want to file a POSH complaint, but I want some kind of action to be taken on that person. So this can be settled through conciliation, okay. So a conciliation process is basically an informal way of resolving complaints before it is escalated to a formal investigation. So before the filing the complaint, POSH complaint, this can be settled and the aggrieved woman may get justice based on the settlement. So it may it may be possible for the internal committee to resolve sexual harassment cases by conciliation between the parties before beginning the inquiry proceedings, and the monetary settlement should not be used as a basis for conciliation. Means like she is I will give you this much money, but you just don't file this complaint. So this kind of settlement can also be done. So this should not be used as a basis for conciliation. A settlement which is done, it should be recorded by the internal committee or the local committee, and the copies should be provided to the aggrieved woman and the respondent after the settlement is reached. Okay. And if the internal committee feels like this conciliation is not done in a proper way, that it is it is done in under the threat, that aggrieved woman is under the threat of death or losing her career. So because of that, she has agreed to the settlement. If the internal committee feels like that, they may conduct an investigation also under the POSH Act, even after the settlement has been reached. So these are the options which woman has. Then interim relief. So what kind of relief is provided to the aggrieved woman? So in response to the complaint, the local committee or internal committee may recommend interim measures to the employer, include the following, which is relocation of the aggrieved woman or the respondent. Any of them will be relocated to other office, other branch of that company. Second is additional statutory or contractual leave of 3 months allowed to the aggrieved woman. Additional leave shall be given to her to cope up with the trauma or whatever mental suffering she is having. So to cope up with that, she can be given additional leave of 3 months. And refraining the respondent from reporting on the performance or of the aggrieved woman, or writing her confidential report, which can then be delegated to another employee. So totally they will be separated from dealing with each other, from reporting or any type of work they were performing together prior to this complaint. That will be totally stopped. So all these things can be done under an internal complaints committee. But what if the internal complaints committee or the company fails to address or hear the complaint, or to resolve this complaint, or to come under any kind of settlement? So what is the remedy available to an aggrieved woman? So she can file a complaint. She can file a complaint under section 354 for outraging the modesty of a woman, under section 354A for sexual harassment by a man, section 354B, assault or use of criminal force to woman with intent to disrobe, section 354C, voyeurism, section 354D, stalking, and section 509, insulting the modesty of a woman These all sections of IPC 1860 deal with the sexual harassment, and the aggrieved woman can file a FIR, a complaint, in the local police station under jurisdiction. So this remedy is also available under IPC. So what kind of punishment is specified under this Act, POSH Act? And what type of punishment and what is the compensation given to the aggrieved woman? So an employer may punish an employee in the following ways for engaging in sexual harassment in accordance with the POSH Act. So the punishment can be described in the POSH policy. So every company has its own POSH policy, and they have mentioned all kind of punishments or compensation in case a person is tried for sexual harassment. Then whatever the punishment mentioned in that policy, that will be applicable on that person. And in case there are no such punishments mentioned in the policy, then the disciplinary action may be taken, like giving a written apology to the aggrieved woman, giving a warning letter to that respondent, reprimanding him, censure, or withholding of his promotion, withholding of his pay rise or increment, then terminating the respondent from service, undergoing a counseling session, or performing a community service. So these type of disciplinary actions can be taken, and even reduction of the respondent's wages to pay the compensation to the aggrieved woman. So whatever the salary he has, that will be reduced, and that amount, the reduced amount will be used to compensate the aggrieved woman. This is under the section 13 of the POSH Act. So under the POSH Act, under section 15, it also provides for compensation for aggrieved woman. So what are the factors considered while calculating the compensation or giving compensation? What are the factors considered? Are the affected employees' mental trauma, pain, suffering, and emotional distress? Like what kind of stress she is going through? What are, if she is suffering from mental trauma, she might have visited the doctor, she might have visited the psychiatrist to relieve, get herself out of this. So whatever the medical expenses she is giving, those will be considered. Then the second is the loss of career opportunities caused by sexual harassment. This sexual harassment sometimes create a very, very huge impact on the aggrieved woman, and she may lose her confidence of going again to the office, and she might damage, or she might finish her career because of that. So this is also considered as considered for determining the compensation. Then the physical and mental health treatment expenses incurred by the victim, whether the alleged perpetrator has high income or a high status, right? Like if that person is a well-known person, is a reputed person. So that time also he is using that reputation, that position, and he used that position for doing the sexual crime. So this thing also is considered while determining the compensation. And then whether a lump sum or installment payments are feasible, what can be given, how it can be given, that is considered. Then a failure by the respondent to pay the aforesaid sum will result in the internal committee forwarding the order of recovery to the district officer concerned. So in case the respondent fails to pay the compensation, this matter will be forwarded to the district officer. And the foremost thing is whether the complaint filed by the aggrieved woman is true or false. Like if a malicious or a false complaint has been filed by the aggrieved woman, she will be punished. So this main thing is firstly considered whether this complaint is valid or invalid, and then other inquiry and other investigation is proceeded. Then comes the confidentiality provisions. So under section 16 of the POSH Act, it recognizes the sensitivity associated with the sexual harassment and places a high priority on maintaining the confidentiality throughout the process. So in many cases, what happens, like a woman, she has requested to not mention her name anywhere, right? Because that might damage her reputation, she might finish her career because of that, because people will start talking about her, and she's afraid that what her family will say, what her relatives will say. So sexual harassment cases are mostly confidential and be very excuse me. So sexual harassment cases are considered topmost priority to be maintained for confidentiality. And if such kind of confidentiality is not maintained by a person who is dealing in these cases while conducting an inquiry or making recommendations, then if that person breaches the confidentiality obligation, then under section 17, he will be punished with a fine of rupees 5,000. Okay. Then vicarious liability of the employer. So because of the Vishaka guidelines, it allows the employers to hold employers accountable for breaches of their duties. So in the Delhi High Court versus Delhi High Court, in US Verma, Principal Delhi Public School Society versus National Commission for Women, it was held that the employers have a personal responsibility to protect others from harm and are not permitted to abdicate this responsibility by delegating it. So the employers, it is the first responsibility of the employer to give a safe workplace to the employees, to create a fair, secure, and comfortable, safe work environment with no chances of discrimination. So he cannot delegate, or he cannot waive off his responsibility, or he cannot say that I'm not responsible for that. So it is for foremost responsibility, liability of the employer. So what are the duties and obligations of the employer? So if you are working in a company and you are a victim of sexual harassment, you need to approach your employer. Okay, and what will be his responsibility in this case? So section 19 of the POSH Act mandates not only the establishment of an internal committee and the timely redress of workplace harassment grievances, but also certain other responsibilities on employers, which such as creating a gender positive workplace, maintain a safe work environment, develop prohibition policies, like what kind of acts are prohibited and what kind of acts are considered as sexual harassment. And it has to display the penalties of such acts or the composition of the committees. The company has to place a notice or place a abstract of the POSH policy on in the center of the workplace, wherein all the employees can read those penalties or the policy, and they will understand what type of acts are considered as a sexual harassment and what type of penalties are given to that in case of such acts. And then employer has to conduct regular workshops, conduct trainings. Trainings are considered like they can be given twice in a year. Then the company has to provide the contact information of all the committee members. Then provide necessary facilities for the members of such committees to carry out their duties. So whoever the committee members are, whatever their requirements are, the employer has to facilitate those requirements for an effective redressal of the complaints. Then yes, so we'll come to the conclusion now. So POSH Act has been a very major step for ensuring a safe and harassment-free work environment for all employees in India. But this POSH Act is specifically for women, only for women. POSH Act is framed, but it doesn't mean that men are not covered or men are not protected. Then men are also protected under IPC. You will not be covered under POSH Act, but you have another remedy under IPC, or you can directly go and file a complaint or an FIR in a local police station under your jurisdiction. So my term means many men have this question that if only women are covered, where we can file our complaints, how are we covered or how are we protected? So this is the option you have. You can go and register your complaint in the local police station. So POSH Act has significantly impacted the workplaces in India, and it is providing of sexual harassment, providing victims of sexual harassment with the legal protection they need. So POSH Act has been enacted, but this act can be effectively implemented only with the help of the employer and the employee, both. They need to work together to create a safe and harassment-free working environment. And that's the main purpose of the POSH Act. So I'll tell you about some of the acts which are enacted in other countries also, because sexual harassment at workplace is everywhere, like it is happening globally. So United States, it has a Civil Rights Act of 1991, which prohibits the employment discrimination based on race, color, religion, sex, and national origin. In Canada, we have a Canada Labor Code, where the Part 3 establishes and protects the workers' rights to fair and equitable conditions of working. Then in Japan, we have equal employment opportunity law, of which the Article 21 prohibits discrimination against women in vocational training, fringe benefits, retirement, and dismissal. Then again in Australia, we have the Sex Discrimination Act 1984. Part 1, Division 3, Section 28 says that sexual harassment prohibits discrimination and any form of sexual harassment of workplace. So there are many countries, almost every country have their own acts which deals in sexual harassment complaints. Now let's come to a few questions which you might have. Is it possible for both men and women to be victims of workplace sexual harassment? Yes, it can happen to both men and women. Okay, but the POSH Act is available only for women, like I told before. So does verbal conduct constitute sexual harassment? Yes, the verbal harassment of a sexual nature may constitute sexual harassment if it is possible for words to be offensive in the same way as physical acts and touches. So in the workplace, sexually colored jokes, comments, and the stories or some type of taunts, like it can lead to sexual harassment and create an environment that is hostile. Do the parties involved in a claim of sexual harassment have a chance to resolve the issue through mediation or conciliation? Yes, like I told you before filing an the investigation starts, the authorities may connect with the person, aggrieved woman, and if aggrieved woman requests the authority, the committee, to resolve this through mediation or conciliation, this also can happen, but no monetary settlement can be reached. Then does the company's HR manager have authority to investigate complaints? No. An investigation must be conducted only and only by the internal committee. Does every branch or office need to have an internal committee? So this is a very good question, because like if you have if your company has 10 branches and your head office or your main branch is in Mumbai, or you can say in Delhi, and the other branches are overall India, the internal complaints committees composed only in Delhi, the main branch. So this will not happen. You have to formulate internal complaints committee in every branch. Okay, wherever the criteria is fulfilled, like if more than 10 or more women employees are there, then you have to formulate a internal complaints committee in every branch. So do the parties involved in a claim of sexual harassment have a chance to resolve the issue? The same thing. Yeah. So this is the end of the training session. So now we can take up the questions, and if you have any type of questions, you can just unmute yourself and ask, or you can drop your message in the chat box.
Sure, Asmita, and thanks a lot for this wonderful session, and this is very informative actually. I hope our participants has also gained a lot of knowledge out of it, and would request you to drop your question in chat box, or you can ask Asmita directly on this.
Can I have a query directly to Miss Asmita?
Sure,
Yes,
sure.
yes.
Yeah, hi, good evening, everybody. Myself, Shima. I'm from Modern Properties, client of your opportunity team, right? I'm from Kolkata, West Bengal. My query is actually there is a confidentiality clause according to POSH Act 2013. Ms. Asmita has mentioned that if somebody, a female employee, if she faced any sexual harassment, so then she can move for employer. But as if there is an established or constituted IC, then there should be some confidentiality clause, and victim can't reach employer except IC members. Victim can't give any kind of information to any other team, any other employer or employee. So that is the main part of confidentiality clause as far as my knowledge is concerned. So please give clarity on that part. IC can give their report, annual report to the employer or management, whatever they have decided, but victim can't reach directly to the member, to the employer.
So you are asking that whether IC can help in this situation if that aggrieved woman is not able to reach to the employer, right?
No. Actually, my query is, you mentioned that victim, that is aggrieved women, can reach to the employer when she has faced any sexual harassment. So my query is, according to the Act guidelines or provisions, it has mentioned that victims should reach, aggrieved women should reach to the IC. That is the reason IC should place the abstract in the conspicuous place, right? So. So if that person, aggrieved women, is reaching to the employer, then favorism comes. Then what is the need for independent IC? That is my question.
Yeah, the thing is, employer's responsibility is to create a safe workplace environment, right? So he is the first person who will be if there is an understanding or there is a that type of environment created by the employer that the victim feels safe to go to the employer, then she can approach the employer. But a separate committee is purposely composed for that purpose, which will handle only these cases. Okay, so the victim has to approach the internal committee first, or she can, if the see, it might happen like in internal committee itself, that person has harassed her, right? The member of that committee is the main respondent or is the main culprit. So she can't go to the internal committee, right? She can
Why
approach.
not? Internal committee has different members. They have external members. They have another members also. Only one person is not the member for to entire IC. So she can reach any other person.
Any other person also, but the thing is, like, she can approach the employer also. So both the authorities should be open for her. Both the person should be open for her. Like, she can approach to the employer also, and she can approach to the internal complaints committee also. But the authority to decide the cases is only with the internal complaints committee. Employer can't decide something on this. What he will do is, he will assist her. If she approaches to the employer, he will assist her how she can deal with this case, how she can approach to the internal committee, what assistance will be provided to her. That will be help will be provided by the employer. So that IC is the main purpose of IC is this, that they have the authority under CPC, like they the orders or the whatever the resolution is given by the internal complaints committee, right? That will be under a CPC, like a code of civil procedure has given them authorities that they can decide the cases and resolve the cases. But they have not given.
That's the main point, because IC has the civil rights. So if there is a constituted IC, and at the time of giving any kind of maybe training to the awareness training to the team, if IC the team is giving proper training to the entire employee members, so that if there is any kind of harassment, they should reach to the IC only. That is the main aim of the making this POSH Act, because before POSH Act there was employer, but maybe maybe many a time empathy matters, and that's the reason ki inconspicuous place there should be the president or presiding officer's name, mail ID, and phone number, and other members' name and phone numbers should be there.
Right. You are
Yes.
right. Yes.
Yeah.
So the foremost person or the first person they can approach is the IC committee.
Yes, yes, true.
Yeah. And then if they feel like I want to approach the employer, if she is unaware that there is an IC in the company, right?
Yeah, then she
Then
can.
she can approach to the employer as well. Okay. Clears your query?
Yeah, sure, sure.
Yes, yes. Thank you. Yes, anyone else?
I have one query, please. This is that it is a very confidential. It is a very confidential matter of for a sexual committee. I mean, for a gentleman who's undergone a sexual harassment case and he's lost it or whatever it is. But suppose if a company asks for a reference, is the HR bound to give reference that he was under a POSH, he had suffered a POSH case under him, or he was undergoing a POSH case? Is HR bound to tell for a reference check whether it was that he had faced a POSH committee or something like that?
Sorry, I didn't get your question.
Say suppose gentleman X has faced a POSH proceedings, right? And it is there in his, there would be some, it'll be there in his file, right? And suppose he leaves and he goes to another organization and they're doing a reference check.
Background verification, you want to say?
Absolutely.
Okay.
So is it the current HR bound to reveal that he was under a POSH?
See, at the time of background verification, the people who have hired the agency for background verification, they strictly adhere to their terms and conditions. Like if an employee's background verification is done, all the things, all his past matters, even if he has committed any crime or any FIR is filed against him, that is also checked, because they go to the police station as well to check the background of that person.
True.
So yes, so HR has to give such type of references. It is not anywhere mentioned that like it is mandatory, but as a good HR practice and for the benefit of the other company or their own also, they have to mention it to the person who is doing the background check.
Okay, so that means confidentiality clause does not work here, right?
Yes, only in certain cases wherein it is a requirement, or this is needed, very much needed for the person, for the company to do a background check, and it is their like responsibility. And if they hire such type of person, okay, and anything happens in future, again the same things, the sexual harassment, then it might affect the reputation of the company also, because it might go viral that this happened in this company, so it might damage the reputation of that company. So companies mostly cover all these things, and they check very thoroughly the background of that employee or the candidate.
Okay, thank you.
Yes, thank you.
Miss Asmita, I will disagree with your point because in our sensitization training, it was strictly mentioned that as an HR, I can never reveal any kind of confidentiality clause. That will be breach of confidentiality clause. So whenever there will be some reference check from a new organization, I can mention some misconduct, but I can't do declare about the POSH Act and about the confidentiality matters in anywhere.
Yes.
Yeah,
Yes,
because
yes.
these will be the breach of a confidentiality clause, because many a time if the victim has made some complaint and respondent has just left the organization without concluding the POSH trials and many other inquiries. So at that point of time, if the next company asks for the reference and the previous company HR reveals the matters, then it will be breach of the confidentiality, and it never allows, actually, according to the Act.
Yes. See, what happens is if the HR has mentioned some kind of misconduct, okay, so that misconduct, if that person who is conducting background verification, they might again ask you in written, like what kind of misconduct was happened against that person. So in that case, if the company allows, then they can disclose specifically that the person was involved in the sexual harassment. But as you said, that some kind of misconduct was there on a part of that candidate or that employee. So even if they have mentioned, it comes under whatever misconduct has been happened. It may be professional misconduct, or he might have violated some kind of policies, or he might be involved in some kind of crimes or sexual harassment. So what kind of misconduct was done by him? This will be asked by the background verification doing agency. So in that case, with prior approval of the senior authorities or the main employer, they can share the details, I guess. Yes. I hope it answers your question. Anyone else?
Okay. Asmita, Sanket has a question on a chat box. So if
Yes.
Sanket is there, he can ask directly to Asmita.
He has mentioned that since POSH is applicable to domestic workers, can anyone on behalf of a aggrieved woman file a complaint? What will be the suggestion for a woman whether to approach police under IPC, local committee under POSH, or authorities under the Domestic Workers Act 2008? Can anyone on behalf of the aggrieved woman file a complaint? Yes. Like I told you, any of her co-worker or her legal heir or a legal representative, her friend, okay, anyone who knows about that incident, that person also can file a complaint with the local police station or under the POSH Act. Yes. And the domestic workers can file a complaint through someone else. Like I told you, if she is not capable of filing the complaint by herself, she can file it through someone else also. Yes, Vandana has asked, like, what guidelines or policies or documentations with respect to POSH should be followed by the companies with less than 10 female employees. So you can, to be over inclusive, you can formulate your own POSH policy, even if there are less than 10 employees. They have given this criteria just to make just to keep in a safer side, that if there are more than 10 employees, the company has to has to make a POSH policy. But the POSH policy can be prepared by every company, and I would suggest that every company should have this policy, even if there are less than 10 employees, less than 10 female employees. Do we need to display that policy in office premises, or just a documented policy circulated within employees is enough? No, we need to display this policy in the office premises itself, and it should be made available in your HRMS portal also, or on your website, means whatever your HRMS portal is there. It should be handy to the employees, this policy. Whenever they want it, they can read it, or you can directly connect with the HR for that purpose. Yes, anyone else? I guess most of the questions are covered in the
Yeah, you have
session
covered all
itself.
the questions. Anyone has any questions, so they can ask directly to Asmita. Okay, there is no new question.
Okay. So I guess we can wrap up the session then.
Yeah, sure. Asmita, again, thank you so much for this session. Thank you, Kush sir, for this. And also would like to thank you all participants for their time and participation. Thank you, everyone. So we can end the session over here.
Yes, thank you everyone. Thank you for joining, and thank you for giving this opportunity. And we would like to align with you for coming trainings also.
Sure.
Yes.
All right. Thank you, everyone. Good day.
Thank you, everyone.
Thank you.